So welcome everyone to this further podcast for the Japanese law series. Delighted to have with us two Osaka-based lawyers, Bengoshi, Jiri Mestecky and Yoshihiro Obayashi.
Thank you very much, Luke, for having me on today. I am, again, Jiri Mestecky. I'm a partner with the law firm of Kitahama Partners. We're one of, Japan's larger law firms. We have our primary office in Osaka, but we also have offices in Tokyo and also in Fukuoka. I am what is known as a registered foreign attorney, or Gaikukou Jimu Bengoshi in Japanese. My original certification or licensing is in the United States, in the state of Illinois. I came to work at Kitahama in 2003. So, I've been here for a number of years now. My primary practice is in the area of intellectual property and also of corporate and commercial transactions. On the dispute resolution side, I also do arbitration and some litigation support.
This is Yoshihiro Obayashi. I was qualified in 2008 in Japan. And then at the fifth year as a lawyer, I went to Singapore, then studied at the Singapore National University of Singapore there for 1 year. And after that, I worked at local law firms in Singapore, Indonesia, and then Thailand. Then I came back to our original law firm. So my major is cross-border transaction, especially in Asian countries. Mm-hmm. Then our law firms are now about 60 lawyers. A little bit smaller than Kitahama Partners, but still one of the biggest law firms in Osaka. Yes.
Actually, the work that I did in Chicago and the work that I've done here in Japan, in Osaka, is actually very similar. Same types of deals, same sort of trans-Pacific, business transactions. So there's been a lot of more similarities than I thought actually would exist. So I think that for me has been a really interesting point. The differences, there have been those as well. Of course, there's a certain way in which Japanese clients in Japan like to receive their services. So it's not just about linguistic fluency; it's also about cultural fluency, and that I think is something that working in Japan, it's invaluable to get that experience. And so that has been, learning and that cultural fluency over the years has been something that has been really fascinating and interesting for me personally.
The number of Japanese clients who can speak English very fluently is very limited. Then they usually don't have many experience in cross-border transactions. So we Japanese need to sometimes translate the English itself. And also we need to explain the difference between the legal systems and the cultures and the religions, the traditions. So we Japanese try to become a more and more good interpreter between such differences. That is a main work. The Japanese judges and Australian judges are very trustable and then very more professional, right? But still, some judges in Asian country is sometimes they don't know the law itself. Then we cannot sometimes trust the court. So the big thing the Japanese clients has always has is they don't have any good resolution measure in Asian countries. So they always trust the judges, but the same will not apply to the other countries, especially Asian countries.
Thank you. So I guess that explains why there's been a long-standing push from Japanese organizations to try to educate, especially smaller companies in Japan going offshore, about the advantages of cross-border arbitration as a dispute resolution mechanism to agree on in advance. And we're going to have a separate podcast about that, so we won't go pursue that further, but thank you. Jiri, do you have anything to add on that point?
Yeah, certainly. It really sort of, depends on the client. So, our larger, multinational corporation, very sophisticated Japanese clients, they know very well and usually have a great deal of experience in dealing in foreign jurisdictions and law firms and lawyers. And so, a lot of the people in the legal departments of the major Japanese clients and corporations are very sophisticated and know, very well. About the idiosyncrasies. Then of course you have smaller clients who you do need to, educate more on, basic things, length of contracts, the proper means of notarization, all of these basic things. So in my experience, it really depends upon the particular client, and you have to adjust your explanations, and you have to adjust the level of advice that you give, of course, based on the particular client you're speaking with. Areas where I thought there would be change but really hasn't been change is, I thought as a foreign attorney by now in Osaka, which is the size of the city of Chicago, that by now we would have been flooded with foreign law firms. That we would have had a huge, I came in 2003, and there were some of us here then, but I would have thought that most of the major American firms and maybe some of the Australian firms as well, and certainly the European, British firms would all have offices down here by now. They don't. That's for a lot of reasons. I think that the main thing that I think caused that is the the law has been very slow to change, as far as, although there have been updates, and maybe we'll get into that, but the law has been very slow to change. Number two, the financial crisis. Most of these firms do a lot of M&A and finance. In 2008, it wiped out a lot of them. So that's something that I thought that would be different, that has been. One of the things that I think has changed, and I think is very positive, is our Japanese clients' outreach of attorneys actually into Asia, into East Asia. I'm sort of a child of the Cold War, where Japan was sort of separate from Southeast Asia and China and other places. Now our firm, I think a lot of other Japanese firms, I think Obayashi Sensei's firm as well, we're very active, becoming very, very active, really in all parts of Asia, which is a great thing.
One of my specialization is M&A, cross-border transaction. Then if you're looking back 5 years ago, almost our work was in relation to the investment into the other countries, especially in Asian countries. But nowadays, the investment into Japanese markets is also increasing. So in such case, some foreign lawyers contact me, and then we are required to do the due diligence work against the Japanese target companies. Such work is relatively increasing nowadays. So the market has really changed.
I think that, one of the very exciting things that is happening, although it's been sort of a long time coming, is sort of the changes in Japanese law relating to foreign attorneys. So, as you know, Luke, there was earlier this year, 2020, in May, the Japanese government passed measures which are, going to allow, for example, expansion of foreign counsel in international arbitration as well as mediation, reducing the amount of overseas experience necessary for foreign lawyers to practice in Japan to become registered foreign attorneys, and also enabling, further cooperation or corporations, actually, or legal corporations, to be established between Bengoshi, Japanese lawyers, as well as foreign attorneys, guidance. So I think that's exciting, and I'm looking forward to see how that impacts the market. I also, think that, we're going to be continuing with a, sort of the service-based information technology. It's going to become more important than ever, and it's going to become important for lawyers to understand and be fluent in those related issues, whatever area of law they practice.
The Japanese lawyers very afraid that the foreign lawyers will come into the Japanese market in the past days, but nowadays we are more and more open. We should be more open. Then, the number of foreign lawyers is very increasing in Japan, but still we can cooperate with them. Then we can make our Japanese markets more attractive, the lawyers. So we should be more cooperative. Don't be afraid. So.
Right.
So yeah, I mean, I think the first thing that immediately comes to mind in response to your question is the communications technology that we have today. I am, amazed. Don't get me wrong. It's inconvenient sometimes not to be able to travel abroad or see your clients, or to be able to meet face to face or go to events. But at the same time, given the dire circumstances and nature of the pandemic, it's amazing to me that our firms, because of the technology, have been able to continue and provide service to our clients. I mean, we adjust our schedules and try to reduce the amount of time in the office, but our firm is very busy, and I think it's really because of the Zoom and a lot of the other technologies that exist today that allow us to keep communicating and continue to work. So if this had happened 10, 15 years ago, I think we could have been in a very, very much worse situation. So the technology is one thing. The other, there are certain areas, and I think the technological aspect is going to teach us something and will continue beyond the pandemic, because it does provide a lot of efficiencies in many ways. As far as areas, I think that, if you're in a full service law firm, you kind of have the ups and downs of economies and societies and times. So, when one area is up, the other is down. So M&A might be down, but now, employment, issues are up. So you as an attorney, you just kind of have to, ride the wave and, be prepared as an attorney and as a firm to deal with the various, different legal issues which the times throw at you.
Actually, to be honest, the Japanese court procedures are very old-fashioned, I would say. And the courts doesn't accept the emails, and only they accept the faxes. We are required to go to the every court hearings physically, but due to or thanks to the COVID-19 pandemic, now the courts are using a team for having the court hearing, so we can communicate with the judges online right now. So that is a good impact on the court procedures. And then I hope that the Japanese court procedure will be more and more sophisticated. Then we should use such ID measures.
Yes, some good things do come out of the pandemic and a crisis like this, including this opportunity to take more of your valuable time. Sorry to interrupt your day. And we really do appreciate all the effort you've put into developing our Kyoto seminar program over many years, and want to wish you all the best in your respective practices moving forward, and hope to see you physically, maybe not next year, but the year after. Thank you.